the Supremacy Clause applies. The Supremacy Clause applies.
Well,
You want to change your answer?
Senator, I would like to change my answer to the extent that I agree with you that the Florida legislature or Florida could do exactly what you said. I meant in my statement is that...
Trust me, it can.
Hey everyone, welcome back to the channel. Today I'm diving into a heated Senate hearing where Senator John Kennedy grilled judicial nominees on some of the most fundamental constitutional issues. From warrants to civil rights law, things got pretty tense, and honestly, some of the answers may surprise you. Stick around because this one gets very interesting. And before we jump in, make sure you hit that subscribe button so you don't miss out on more breakdowns like this.
Senator Kennedy to kick us off.
Thank you, Madam Chair. Judge Dudick, did I say that name right?
That's correct, Senator.
All right, what's the warrant requirement?
Well, before the court would issue a warrant, you have to assess to make sure that there's probable cause to either search the place.
When's a warrant required?
Excuse me?
When is a warrant required?
The general rule is a warrant is required any time that the government wants to search a person, place, or thing.
Could you speak into the mic?
Oh, I'm sorry, Senator. Yeah, I said the backdrop rule is that a warrant is required any time the government wants to search a person, place, or a thing.
And to arrest you, right?
There are some exceptions to that, but generally, yes.
Okay. And there are exceptions to the warrant requirement for searching and arresting people, are they not? Are there not?
Yes, Senator, there are.
Okay. Suppose the Florida Supreme Court ruled that here in Florida, we're not going to recognize any exceptions to the warrant requirement. You have to have a warrant to search someone, and you have to have a warrant to arrest someone. Mm-hmm. No exceptions. Can the Florida Supreme Court do that?
Well, Senator, under the Supremacy Clause, they'd be bound by what the Fourth Amendment dictates. Of course, they're free to make their own requirements as it...
What if the Florida Supreme Court did it under the Florida Constitution and not the federal Constitution?
Well, they would still, Senator, have to apply with what the federal Constitution said.
No, they wouldn't.
Under the Supremacy Clause.
Do you know what adequate and independent state grounds means?
Sure. Of course, I would understand that they could have independent and adequate state grounds for state law, but they...
No, they don't. As long as you don't take away rights, but add to them, a state can do whatever it wants to under its state constitution, can it?
Yes, sir. Yes,
but
Senator.
That's not what you just said. You think the Supremacy Clause applies? The Supremacy Clause applies.
Well,
you want to change your answer?
Senator, I would like to change my answer to the extent that I agree with you that the Florida legislature or Florida could do exactly what you said. I meant in my statement is that...
Trust me, it can. Judge Pruitt, I'm sorry, I can't see that far.
It's Judge Pratt, Senator. Yes.
Judge Pratt, I apologize. I can't see that far. Can a state legislature pass a law that discriminates against a group of people over another group of people for inferior treatment?
Well, Senator, the federal Constitution and the state Constitution both contain protections against various forms of discrimination.
But can a state legislature say we're going to treat this group of people differently than another group of people?
So I think, Senator, an example where a legislature
could...
But
tell me first if a state can do that.
Yes, a state can, for example, require a driving age which discriminates on the basis of age. To say, for example...
When can a state legislature not do that?
When it's seeking to do so under a basis that is protected under the state or federal Constitution.
Okay, good. Judge, tell me about the Privileges and Immunities Clause.
The Privileges and Immunities Clause There's a privileges and immunities and a privileges or immunities
Right.
clause. There's one of each. One of them relates.
Privileges and is what I'm asking you about.
I believe you're referring to what came through in one of the Reconstruction amendments and discussing the fact that that the privileges and immunities of citizenship would be extended under those.
First, what article is it in?
I believe it's in the 13th Amendment.
No, 4th. Article 4. What does it do?
Senator, you have pinpointed a question that in my 9 years as a judge, in my decade of private practice before this, my 2 years as a law clerk, my 2 years on law review in law school, including a year as editor-in-chief, didn't ever come up.
You tell me you don't know?
So first up, Kennedy put Judge Dudick on the spot about the warrant requirement. Dudick explained that warrants are generally needed to search or arrest someone, but of course, there are exceptions. Kennedy then asked a tough question. Could a state Supreme Court like Florida's refuse to recognize those exceptions? At first, Dudick leaned on the Supremacy Clause, saying federal rules would override. But after being pressed, he admitted, yes, states can actually add extra protections under their own constitutions. Next, Kennedy tested Dudick on adequate and independent state grounds, pointing out that states can always give citizens more rights but never less than what the federal Constitution allows. Then he moved to Judge Pratt, asking whether a state legislature could discriminate against certain groups. Pratt answered that some distinctions, like age restrictions for driving, are allowed. But when it comes to race or other protected classes, both federal and state constitutions prevent unequal treatment. Things got awkward when Kennedy asked Pratt about the Privileges and Immunities Clause. She first pointed to the wrong amendment, then admitted she wasn't sure. Kennedy pushed further about the Privileges or Immunities Clause under the 14th Amendment, but again, Pratt couldn't provide a confident answer. This exchange clearly showed that not every nominee was fully prepared for the senator's grilling. Kennedy then turned to Judge Arto with a direct question. What does Title VI of the Civil Rights Act of 1964 do? Arto fumbled, saying it broadly prevents discrimination, but Kennedy quickly corrected him. Title VI specifically prohibits discrimination based on race, color, or national origin when federal funding is involved. That's a huge detail for anyone who might see this law on the bench. By the end of the hearing, Kennedy made one thing clear. These judicial nominees need to brush up on the basics before stepping into federal courts. From warrants to civil rights protections, it was a tough spotlight on how well, or not well, prepared they were. If you found this breakdown helpful, don't forget to hit that like button, leave a comment with your thoughts on how the nominees handled these questions, and of course, subscribe for more deep dives into politics, law, and current events. Thanks for watching, and I'll catch you in the next video.